lecture series, I think is a fitting tribute to her. In 1971, Dorothy co-authored a report on the status of women at Kansas State University. And as a result of that report, both the Commission on the Status of Women and the Office of Affirmative Action were created. Dorothy, as we all know, served with distinction as the first Affirmative Action Officer at Kansas State University and later as our Associate Attorney. I knew Dorothy for 25 years, and I served in the Affirmative Action Office. I worked closely with her on a number of occasions. She was helped to draft our sexual harassment policy and our policy prohibiting racial discrimination. And so certainly this lecture and this series fitting tributes to her. The Dorothy Thompson Lecture Series is sponsored by the Office of the Provost, and it's co-sponsored by a number of university departments and offices and colleges. Those are listed in the program that you received tonight. In addition, First Bank is our corporate co-sponsor, and I want to take this opportunity to thank all of our sponsors and co-sponsors for their support. In addition, this series would not be possible without the generous support of the patrons of our series, and their names are also listed in the program. We would not be here tonight, I say, without their generous support. And I want to thank each and every person who has contributed to this series. I now want to call Robert Luttrell, who's a member of the Dorothy Thompson Lecture Series Committee, to introduce our distinguished speaker.
Thank you, Jerry. Over 200 years ago, the French-speaking Arcadians of Nova Scotia were asked to leave their homeland. They resettled in Louisiana, at that time a French possession, and became known as Cajuns. They brought with them treasures then unrealized to the United States, cultural richness, the fabric of American culture. We owe to them such things as etouffee, shrimp Creole, generations of French teachers and Louisiana politicians. As it concerns us here tonight, however, it brought the forebears of our speaker, who might otherwise be teaching law at Quebec Law School. Our speaker's parents, whom you may know as Manhattan residents, former Manhattan residents, are here with us tonight. Joseph Hebert and La Plus Belle Barbara Hebert. It was I who persuaded Joe to run for the legislature in 1978 when daughter Camille was 19 years of age, an experience that I'm sure that he has not yet recovered from. Many of you also know our speaker, Camille, because she grew up here in Manhattan, matriculated through the Manhattan Public Schools and K-State at breakneck speed, her college degree being obtained only 2 years after her high school diploma attained. She attained her law degree at the University of Kansas. In 1982, went on to clerk at the 10th Circuit Court of Appeals, was in private practice in Kansas City as a large law firm, before joining the faculty of the University of Ohio Law School, where she's currently an associate professor. She has established a national reputation in her publications, which focus in large part around the issues of sexual and racial harassment, employee privacy, and alternative dispute resolution. She teaches courses in employment discrimination, has a sexual harassment seminar, and teaches legal writing. Tonight, she addresses us on the topic of drawing comparisons between racial and sexual harassment. The views she expresses are not necessarily those of the Dorothy Thompson Lecture Series or Kansas State University. I include that jibe only because last night I was fortunate enough, or as it applied to me, unfortunate enough to debate the First Amendment with her. And I learned not to debate with someone whose skills are ever so much more honed than my own. And it is my great pleasure at this time to present to you Camille Hebert.
I'm very happy to be asked to come back to Manhattan tonight. As you know, I've heard, I've done a good deal of my growing up here, and I feel very honored to be asked to give this lecture. For some time now, I've been teaching and researching and writing in the field of sexual harassment law and employment discrimination more generally. I teach a course in employment discrimination, in which I do sort of the standard things people do in employment discrimination. I deal with racial discrimination, discrimination on the basis of religion, discrimination on the basis of gender, etc., etc. And I notice that when I get to the area of sexual harassment, the tone of the class changes somewhat. The students become a little more tentative. Both my male and female students seem to lose sort of some of the strength of their convictions. They seem to have some level of discomfort in thinking of sexual harassment as a form of discrimination. They seem to be, particularly in this area, they seem to be searching for bright lines, for something that will tell them where the line is, what's harassment. They always say, but what is it? What does it look like? And, I say, well, I can tell you what the legal standard is. But they seem, I think, particularly, now all law students want bright lines, frankly, but they seem particularly interested and uncomfortable in this area. Some students openly, and of course we train them to do this, they openly challenge even the assumption that sexual harassment is a form of discrimination. And I've thought a lot about the reasons for this. I've been teaching for 8 years now, and it happens again and again, and I think, okay, well, what's going on here? And the conclusion I've come to is that no matter what the law says, and the law says, in fact, that sexual harassment is a form of discrimination. The U.S. Supreme Court said that 10 years ago in 1986. So I know what the law says, but in spite of what the law says, I think there is a sense that they don't really think of sexual harassment as discrimination. Yeah, the law says that, the court said that, but it doesn't look like discrimination. It doesn't look like what they think of as discrimination. It doesn't look like sort of the intentional, animus-driven discrimination that, for example, racial discrimination looks like. Instead, I think they think it looks a little like sort of normal social behavior, like mating behavior, like behavior that people engage in with someone they like. And that is hard for them to think about when I'm talking about discrimination, which they think of as something you do to someone you hate. And what I'd like to talk about tonight is why I think the perceptions that harassment or things you engage in with someone you like, why that's wrong. And I'd like to talk about some of the methods I use in both my writing and my teaching to explain why I think that's wrong. One way that I've done, what I've been doing most recently, is to try to dispel the perceptions about harassment, what harassment is, by drawing analogies between sexual harassment and racial harassment. And what I want to talk about tonight is both the appropriateness of drawing those analogies and some of the risks of drawing those analogies. There are benefits and there are risks, and I want to talk about both of those. discrimination law generally recognizes two forms of sexual harassment, and I'll try to sort of go light on the law here. You know, I'm a law professor, and so if I lapse into law, I'll try not to do it too much. But just to give you the general background, the law recognizes two types of sexual harassment. One is the one that's sort of classically thought of as harassment. It's called, by a nice Latin name, quid pro quo sexual harassment. It means this for that, I think. I guess what it means in Latin. The idea is that it's an exchange of sexual favors, sexual activity, conditioned on job duties. Exchange is probably the wrong word. It's a thing you think about, most people think about when you think about sexual harassment. The sleep with me if you're fired. The classic sleep with me if you're fired, sleep with me if you want a promotion. That is sexual harassment. It is quid pro quo sexual harassment. Anytime tangible job benefits, promotions, pay, any tangible job benefit is conditioned on submission to sexual activity. Not just sex, but tolerating sexual activity, tolerating comments. That is unlawful as quid pro quo. And most people don't dispute much about that type. Most people recognize that as harassment. The other type is a lot fuzzier. It's called hostile environment sexual harassment. And it basically occurs anytime job benefits aren't conditioned on submission to sexual conduct, but when the conduct becomes pervasive, severe, offensive enough so that the court says it creates an abusive work environment. That's the legal standard. I mean, that's it. That's what the courts have to apply, which you can understand why my law students go, oh, thank you very much, and what does it look like? What the courts basically say is not all sexual conduct in the workplace or in educational settings. I tend to talk about workplace because that's what I do, but in fact, sexual harassment comes up often in the educational setting, between students, faculty, staff, et cetera. Not all conduct is considered unlawful. The law says that the conduct is only considered unlawful when it is severe or pervasive enough to alter the working environment. Basically, the differences between the two types are the existence of tangible job benefits. If there are tangible job benefits involved, it's quid pro quo. If there aren't, it's hostile environment. Now, racial harassment uses very much the same legal terms. People rarely think of quid pro quo racial harassment, although it can actually exist. If you are required to tolerate racial conduct as a condition for holding your job, that is, in fact, quid pro quo racial harassment. But you normally see it in a different setting, that is, where the racial conduct is directed at people, racial slurs, racial references, offensive racial references, are directed at people, their workplace becomes intolerable, their workplace becomes abusive. So the legal definitions are actually quite similar. The law says basically the same standards apply. So given that the law says that, why do people have a hard time thinking about the two types of conducts as equivalent or similar? I think one reason is because people view sexual harassing conduct as sort of fundamentally different than racially harassing conduct, because it has, people believe, different motivations and different effects. But I think, in fact, both of those things are wrong. To a very large degree, I think racial and sexual harassment have similar motivations and, in fact, similar effects. And I'd like to talk a little bit about that. What's the motivation behind racially harassing conduct? Why do people use racial slurs to refer to minority groups? Why do people, and these are actual cases, unfortunately, why do people hang nooses over the desks of minority workers? Why do people make references in the workplace to the Ku Klux Klan in graffiti scrawled in bathrooms and in notes and on posters put on the bulletin board. Why do they tell racially offensive jokes? We know generally why that occurs. They do it, people do it to show hatred. They do it to show disrespect. They do it to demean. They do it to threaten. They do it, I believe, to assert their supposed superiority over the groups. We don't have much confusion about that conduct. We understand that conduct. We understand it is hateful. We understand it is harmful. We understand it's discrimination. And we understand it has no place in the workplace and in educational settings. Now let's think about the motivation behind sexually harassing conduct. Why do people use sexually offensive terms to refer to women? When someone calls a woman a bitch or worse, is it meant as a compliment? No, it's not meant as a compliment. When someone tells a sexually explicit joke, I have quotation marks around the word joke, it's sort of hard to show those, which depicts women in a demeaning or a subordinate position. What's the motivation there? When someone corners a woman in a corner of the dark supply closet and touches her breasts or touches her buttocks, or does the same thing not in a dark supply closet but in the full view of her coworkers, which also happens in some of these cases, what's the motivation? If someone asks for sex as a condition for keeping or a job or obtaining a promotion, what's the motivation? Is this the way we treat someone we like? The answer is no. This isn't the way we treat someone we liked. If we like someone, if we're trying to initiate a truly consensual, romantic, or even sexual relationship, that's not the way we go about it. We don't threaten, we don't take, we don't demean, we don't corner people. We don't use threats of retaliation as a way to win someone's love. We don't threaten to fire them if we are trying to win their love. Why then do people confuse this sort of conduct, coercive, demeaning, harassing sexual conduct, with consensual sexual conduct? Is it simply because we can recognize in all settings the racial conduct is wrong, whatever the setting, but the sexually harassing conduct resembles in some way conduct that is not wrong in certain settings? There, I think the answer is yes. Let me explain to you why I think that approach is wrong. There is, in fact, some facial similarity between conduct that is sexual harassment and unlawful and conduct that is consensual sexual relationship and it's not unlawful. When someone initiates a consensual romantic relationship, although it's usually later on in the relationship, not when you're initiating it, one might use similar words to the words one uses when you're engaged in sexual harassment. Take the words, "Will you sleep with me?" If those words are used or uttered in the context of a mutual, consensual, loving relationship without coercion, we understand the implications of those words. That's not sexual harassment. That's not unlawful. Let's take those same words and now utter them in a context in which there is some coercion involved. Let's utter them in the context of a boss talking about his secretary or his subordinate's annual evaluation. And there are those cases. The United States Supreme Court decided a case a couple of years ago in which the boss suggested they go to the Holiday Inn to negotiate a raise. So these things still happen. Now those words, put those words in a dark supply closet when someone's being cornered. Now those words no longer look like love or even like, they look like coercion. They look like humiliation. They look like hate. I want you to think about the contrast another way. Take the words, for example, "I need some money." Between friends, uttered between friends, some contexts uttered between strangers, those words look like a request for a loan, or maybe a gift. But put those words in a different context now. Give the person saying, I need some money, a gun. Or give them 6 friends standing around them in a dark alley. Now, or give that person a piece of information they are starting to disclose to the world. Information we would rather not have disclosed. In those situations, it doesn't look like a loan or a gift anymore. In those situations, we can tell the difference between a gift and a loan on one hand and robbery and blackmail on the other. We understand the difference. We don't say, hey, let's not criminalize robbery or blackmail because we might chill the giving of gifts and loans. We don't say that. But we do say similar things in the area of sexual harassment. We say, wait a minute. If we have strong rules, it might chill consensual conduct. People might not be able to ask their coworkers for a date. There are those similar types of comments made. I think to address sexual harassment seriously, we have to stop thinking of it as motivated by sex, by sexual attractiveness, and we have to think about it as an exercise of power. Over people we think we can exercise power over people who we believe are inferior to us, over people we believe don't have a right to say no. It's become almost a cliche to say that sexual harassment is about power. But, cliches become cliches for a reason. They are usually fairly well grounded in fact. Just because sex is used as the tool doesn't mean that it's necessarily the motivation. Someone else has said it better than I ever could. Professor Vera Taylor, in an article in the Capital Law Review several years ago, said, sexual harassment, then, is not about sex. If someone were to kill another person with a rolling pin, we would not consider it cooking. And I think, to a large degree, that's what I'm talking about when we think about the motivation. Now, motivation is just one of the reasons we think about banning, making unlawful sexual harassment. One of the other reasons we make unlawful sexual and racial harassment is because of the effects on the people to whom are subjected to it. It's not just because it's wrong, but also because of the effects. When someone is subject to racial harassment, called a racial epithet, had a news hung over their desk, seen graffiti referring to the KKK, what's their reaction? They're angry and they're afraid. Studies have in fact indicated that among the effects that are reported by people who are subject to racial harassment are rapid pulse rate, hypertension, headaches, dizziness, social withdrawal, chronic depression. We understand that. We understand why those are the effects. We're not surprised that people who are subject to racial harassment, racial discrimination, feel bad, feel demeaned, feel angry. We aren't even particularly surprised that members of minority groups are more sensitive to racial harassment than members of majority groups. One of my friends, one of my colleagues at Ohio State sort of explained it this way to me. She said, if someone walks by you repeatedly, and every time they walk by you, they kick you, well, the next time they walk by you, and, they don't kick you this time, but they start to raise their foot, you react. That is, people who are more used to being demeaned by racial references are more likely to be sensitive to it. White people who, frankly, are not often demeaned because of their race are not likely to be as sensitive to it. And therefore, people who have been racially harassed are more likely to see the harm in racially offensive epithets, comments, and jokes. Now let's talk about sexual harassment. What are the effects of being sexually harassed, of having unwanted sexual attention directed at you, of being the subject of sexual remarks and jokes. For women, and it's mostly women, although men are also sexually harassed, percentage-wise it is more likely to be women, are women who are subject to sexual harassment complimented? Do they feel all warm and fuzzy inside? The answer is no. They feel angry, they feel threatened, and they feel demeaned. Research has indicated the physical and psychological symptoms reported by individuals who have been subject to sexual harassment include headaches, backaches, nausea, weight gain, insomnia, depression, nervousness. Very much the same symptoms that people who have been racially harassed feel. And why is sexually harassing conduct insulting, demeaning, threatening, particularly to women? After all, consensual sexual activity isn't any of those things. Consensual sexual activity is loving, while harassing activity is not loving. I think it's because when sexual activity is taken from its proper place and brought into the workplace and brought into educational settings, the women can tell the difference between being sexually harassed and consensual activity. They can tell the difference between being complimented and being insulted, between being loved and being demeaned and threatened. Just like the person who's handing over money can tell the difference between a gift and being robbed. When women are subject to unwelcome sexual conduct in an educational setting or a workplace setting, they know the terms in which they are being thought of. They're not being thought of as workers, as people who have done a good job, people who have put their life into their job and have worked. They're being thought of as sexual objects. They're being thought of in a different sort of way than they want to be thought of generally in the workplace. Being coerced into a sexual relationship feels threatening because it is threatening. There's nothing friendly about being pinched and prodded and patted by people you don't want to be touched by. There's nothing loving about being threatened with adverse job action or educational penalties for saying no. And there's nothing warm and fuzzy about being called sexually derogatory names or being the subject of sexually derogatory or explicit sexual jokes. Women can tell the difference. A lot of between being harassed and consensual activity. A lot of people ask me, my students ask me, well, sexual activity in the workplace is not directed at women, it's sort of directed at anybody. Why are women more sensitive? And I think women are more sensitive for some of the same reasons that members of minority groups are more sensitive about racial slurs and racial terms. Women are more used to being treated as sexual objects, particularly in the workplace and educational settings, than men are. Men can often be thought of as sexual beings and also good workers. But think of all the stereotypes of women. The being thought of as a sexual object and a competent worker rarely go hand in hand. That isn't consistent with our ideas of women with respect to sex. Women and men are simply differently situated. The posters on the wall at workplaces showing people in various stages of undress are not of men. They're of women. The old sleeping your way to the top, that old sort of reference is not about men, it's about women. Women are simply treated differently with respect to sex, and therefore even sexual references directed at both men and women, I think, are felt differently by women. So far I've talked about why, in fact, I think racially harassing conduct and sexually harassing conduct are similar with respect to both the motivation and the effects. I think, in fact, there are some very good reasons to draw analogies between them. I think there are some very clear benefits. I've been using analogies all through my talk. When I want to try to explain something, I say, see, it's like this. And I think that's a very good use of analogies between racial and sexual harassment. I think one of the positive benefits of doing that is that by demonstrating that sexual harassment is in fact similar to racial harassment in a number of ways, we can recognize it as improper and unlawful rather than just sort of normal social conduct, this is the way things are. People who can clearly identify as wrongful the conduct in one context can also go, oh, yeah, maybe this is like that, maybe this is also wrong. And men and women who engage in sexual harassment might see, in fact, this is wrong. This is like something that I abhor, that is race discrimination. But there are also disadvantages. And in fact, when I first started writing in this area, I only thought of the advantages. I didn't think of the disadvantages. And the more work I've done in the area, the more I've been concerned. One of the dangers is that by saying, I think, racial harassment and sexual harassment are analogous, that I may be understood to say they're exactly the same. And I'm not saying that. Violence against women, sexual harassment of women, is a serious problem. But it's not the same thing as basically our country's history of racial genocide and slavery. It's not the same thing. Oppression and hatred against women is a serious problem, but it's not the same as racial discrimination. But I'm not trying to say they are exactly the same. I'm trying to say they are sufficiently analogous that it makes sense to really apply similar legal standards and similar standards of understanding, similar standards about what we think is proper and improper in the workplace and educational settings. But there's another disadvantage, and this is something I didn't think about at first. It's what I call the two-edged sword of analogy. One of the effects of drawing analogies is you say, okay, we all recognize this is unlawful. See, this is like that. And therefore we should treat them the same. That is, we should take sexual harassment as serious as we take racial harassment. But it can work the other way. That is, what if instead of bolstering the weaker claim, the analogy results in weakening the stronger claim? That is, what if by use of analogies between racial harassment and sexual harassment, instead of bolstering sexual harassment claims, it casts a shadow on racial harassment claims? I see some signs of this happening in recent, and I mean in the last few years, cases decided by the courts in the area of racial harassment. Let me just give you a few examples. And again, I'll try not to lapse too much into law, but to tell you, just to give you a little bit of background, one of the requirements of harassment, sexual harassment, has always been unwelcomeness. In order to prove this is unlawful, the conduct has to be unwanted, unwelcome. We understand what that means generally in the context of sexual harassment, and what the courts generally say is, well, if a person did something to invite the conduct, if they didn't find the conduct offensive, well, then it's not unlawful, then it's not bad conduct. But recently, I have seen a number of cases that have taken the unwelcomeness requirement out of the sexual harassment context and moved it into the racial harassment context. Therefore, courts are saying, well, is this racial conduct unwelcome? Which the first time I read it, I went, wait, what do you mean? I mean, how can you even ask the question? But the courts are starting to ask the question. They say, well, what did the person do? What did they say? Did they ever use a racial slur? If they used a racial slur, whether in self-defense, as you will, or in another context, maybe they really didn't find this offensive. And that's troublesome. If we start talking about the welcomeness of racially offensive conduct, that's a problem. Let me give you another example. Another requirement I mentioned earlier of hostile environment sexual harassment is that it be severe or pervasive. What the courts generally say is a little bit of sexual conduct isn't, that's not against the law. We don't want to sort of bring a federal lawsuit every time we have a little bit of conduct, so it has to be severe, very serious, or pervasive, happen more than once. context of sexual harassment, actually I have some problems with that, but I understand somewhat what it means. But I've seen that same standard applied now in racial harassment cases. And so courts are saying things like, well, how many times was that racial epithet used? Well, maybe if it wasn't used often enough, it's not really serious enough. That's a problem. That sort of analogy saying, well, it was only used 4 times by 3 supervisors and not 6 times by 7. That's a problem. And I think it ignores that the harm that is caused by racial harassment is not simply its repetition, its existence in the first place. Knowing that is what people think of you, it is a problem. So the question is, given there are benefits and given there are risks, is it worth it? And I ask myself a lot, particularly since I'm writing an article in which I'm doing this and sort of decide whether I should still publish the article or whether I have to scrap it. It is troublesome if the courts start saying, well, welcomeness. Is racial harassment really welcome or not? But it can have the opposite effect. Maybe courts will say, well, wait a minute. It's ludicrous to think about welcome racial harassment. Maybe it's ludicrous to think of welcome sexual harassment. Maybe courts will stop saying, as the Federal Court of Appeals of the Seventh Circuit said in a case, that a woman, conduct towards a woman of pushing her head into the toilet, of macing her, and placing a cattle prod between her legs. Maybe they will stop saying that is welcome, because that is exactly what a court did. A Federal Court of Appeals said, well, she told some jokes. Actually, what she did is she didn't wear a bra under her t-shirt. That's basically what she did. And the court said, as a result, the conduct was not unwelcome and therefore wasn't unlawful. Maybe that will be the effect. Maybe we'll go, wait a minute, this is wrong too. Maybe we will recognize, instead of saying, how many times was that racial slur used? Maybe we'll recognize that numbers don't count. And courts will stop saying, as another court did, well, he only touched her breast once. Therefore, it's not unlawful. Maybe we'll recognize that that's ludicrous too. So there are benefits and there are dangers. And how it works out and whether the benefits are worth the risks, it seems to me, depends on whether we use the analogies responsibly and whether the courts draw the right conclusions from these analogies. Thank you. I don't know if there are questions, but if there are questions, I'd be happy to take some questions.
I was curious, when you talk about the law, are you referring to between the state law or the laws nationwide?
The laws are generally nationwide. Sexual harassment and racial harassment are made unlawful by something called Title VII of the Civil Rights Act of 1964, and it is federal law. In fact, there are state laws too. There's a Kansas Act Against Discrimination, that's what it's called, and Ohio has a similar law. But the law generally is federal. The law I was talking about was federal, that is, applies everywhere.
Does that apply also with military, say like military stations overseas?
Well, technically, Title VII doesn't apply to the military. There are some, one wouldn't have to be sort of, have your head in the sand not to have heard about the sexual harassment issues that have come up in the military. Technically, the law does not apply. That law doesn't apply. There are executive orders and those sort of things that prohibit it. And generally, that federal law applies outside the United States, not in the military context, as long as you're talking about an American employer. That is, an American employer employing people overseas, it does count. Obviously, a foreign employer employing people overseas, the law doesn't quite reach that far. We tried, but it doesn't reach quite that far.
I appreciated your caution about the race-gender analogy. However, I think that there are some other reasons why the analogies are more negative than positive. and would like to get your opinion about how to erase some of the negatives, okay? One of the problems with the analogy is that people tend to use race and gender as discrete categories, okay? Leaving people who cross over uncovered, okay? Go with me a minute to the Anita Hill trial. It seemed unfathomable that because she was a black woman or African American woman, that the sexual advance could have been unwelcome, okay? I think largely that situation was explained and understood more on the basis of gender, okay? And the sexual, the racial dimension was kind of downplayed. And so I'm wondering how we can avoid those kinds of situations where we can use the analogies and be inclusive at the same time, or might we need to discount them and look towards the evolution of a better concept?
You're exactly right about many of the negative effects. I mean, there were all sort of implications, racial and gender, of those hearings. All sort of implications I can't even begin to touch. In many ways, it was, I think they would have been different. I would think they would have been handled much differently had both people been white, very differently. And there were clearly racial connotations, both racial stereotypes about the sexuality of black men and racial stereotypes about the sexuality of black women. And it used to be in the law, in fact, that it was impossible to rape a black woman. That was the law, because basically the assumption was it couldn't be coercive, it couldn't be non-consensual. And some of those stereotypes, they're not gone. The law may not recognize them, but they're not gone. And that is a danger. That is a danger of the analogy. I tend to think that there are still some benefits and that it can be a useful analogy, but I am aware of the real implications, the real dangers of it. And it may not be worth the risk in some situations. Maybe it isn't worth the risk at all. I hope I can still publish my article. The law is not very, people tend to think of the law as, is there a law on that, sort of the law being very black and white, excuse the pun or what, but there's sort of the sense of that. The law is really not like that. And in some areas, it is particularly troublesome because you have this, oh, maybe this isn't wrong, maybe it's okay. And I think that to some degree you have that with racial issues and sexual issues. This sense of, is an ethnic joke, is that wrong? Is that unlawful? My theory generally is that if you have to ask that question, the answer is almost certainly that it's wrong. If you really have to think seriously about whether this is something I should be doing, it may not be unlawful, but you can be pretty sure you shouldn't be saying it. Now, maybe that's a too absolutist a position, and free speech people would give me some problems on some of those issues. Do you want to rejoin her, by the way? But it's true that the law has a lot of fuzziness in this area. And in some ways, I sort of wish they'd go, it's about race, it's about sex, don't do it. Don't do it. And it would make my job a lot easier, I suppose, teaching it. But the law doesn't do that.
I say this because I deal with a lot of legal redress situations, and I found that there's always
fact, in some cases, it is harassment of black women that makes it most explicit that these types of conduct are similar. That is, if you can recognize that the same conduct is often harassing on both grounds. That is, that the same unwelcome, demeaning conduct has both racial and sexual connotations. And some people have said, in fact, maybe it is with respect to harassment of black women in which we can finally understand that sexual harassing conduct is wrong and demeaning. Now, the interesting thing about the courts recognizing it is courts tend to say in those contexts, it's one or the other. They don't know what to do with people who are sort of at the intersection of race and gender. Curiously, they don't have much problem with that with respect to white men in affirmative action cases. They understand that intersection, but have a harder time with respect to black women in discrimination cases. I mean, and I've seen this. Courts tend to go, you know, you gotta decide, it's gotta be one or the other. The most troublesome thing the courts, I think, have had is recognizing the existence of intergender or inter-race discrimination, intra-race discrimination. That is, some of the discrimination against black women is in fact by black men. And some of it is racial and sexual in nature. And the courts have a hard time recognizing that. I think it is this inability to believe that members of the same race can discriminate on the basis of race, and that members of different genders, same gender, excuse me, can discriminate on the basis of gender. And the courts have recently, in a number of cases, thrown out same-sex harassment cases by saying, oh, that's not what the law was aimed at.
Just now, kind of touched on what I was going to ask. The analogies about race and about gender, I was wondering, does in sexual orientation discrimination, drawing analogies?
Well, the problem with drawing the analogies is it doesn't help very much from a legal standpoint because the courts say sexual orientation discrimination, not covered. They do. Not sex, not unlawful. There's some constitutional prohibitions, but statutory, unless there's a state statute, Title VII doesn't cover it. The courts have repeatedly said that. So legally, it's not a very useful analogy to make because it's a loser. But in fact, I believe that sexual orientation, harassment, and discrimination is motivated by gender. That is, it is the failure of people who are gay or lesbian to conform to our sexual stereotypes that causes some of the discrimination. But legally, it's not a very useful analogy to make because it's basically a loser. It's even worse than sexual harassment is treated.
In writing a policy to control racial harassment, in writing a policy to control sexual harassment, one distinction that has been suggested is that you can write a policy that controls conduct because that's not protected. Do you treat, but I guess the extension of that is that sexual harassment does recognize that you can address something that is not conduct, but that doesn't carry over to trying to address racial harassment. Do you agree?
For the life of me, I cannot figure that one out. No, I really can't. Speech, right? Sexually harassing speech can still be declared unlawful. The Supreme Court said so, sort of as an aside, but it made the analogy to Title VII and said, see, this can still be unlawful because it's the effects. I mean, basically, it's the incidental effects of the speech that is discriminatory. I don't understand why it doesn't apply in the same context. It is true that most of the free speech cases invalidating university hate speech codes have dealt with the racial harassment issue and have said, oh, you can't do it. But it seems to me the analogy is the same. That is, it is not just the content of the speech you are suppressing, or you're not suppressing it because of the content, but because of the incidental discriminatory effects. And of course, not all sexually sexual references or gender references or racial references are unlawful. I mean, one could have a discussion about, you know, the proper role of the genders or the roles of the races in certain educational settings without, you know, being lawful at all. But when one makes a explicit comment to someone or about someone, it seems to me the rules should be the same. And I haven't quite figured out why the courts haven't taken that step. Law firms are not very well. Law firms are not very, I mean, some law firms are great, but law firms in general are not very good. Probably one, even if one wasn't a lawyer, you noticed the $7.2 million verdict against Baker and McKenzie, the large Houston, I think, firm. That verdict was that high, I think, because they had said, yeah, we know about it, a bunch of women had complained, but, you know, he made a lot of money for the firm, we're not going to get rid of him. The answer is, I don't think much of the legal community's response. Some of them are pretty good. Baker McKenzie's a lot better now, I suspect. $7.2 million verdict probably does that to you. Gets your attention in any event, but it's still not as good as it would be.
I'm concerned about school-age children, adolescents, sexual and ethnic harassment of one another. What is your thinking about enforcement, about legal enforcement, and what have the court cases been on that?
It's a very troublesome area because I think in some ways, even more so between children than adults, people go, oh, but that's just the way kids are. Kids are very cruel. Boys will be boys. That's just the way things are. That's sort of the normal part of growing up. And I think there is that reaction. But I've seen studies that indicate, for example, that the self-esteem of boys goes up in school and the self-esteem of girls plummets. And as now the mother of 2 girls and a boy, that really concerns me. I think it's serious. Now, do you sue the, third grade kid who's calling so-and-so something? No, that's not the way you deal with it. But do you say there have to be some standards? This conduct causes real harm. We have to at least say, not, oh, look at those kids, aren't they funny? But take serious conduct. To some degree, you gotta get them when they're young. Because it's a lot harder to convince them of what appropriate behavior is when they're not so young anymore.
The analogies that you draw between sexual and racial harassment, I think are very valuable, but I wonder whether the dichotomy that you draw between treating sexual harassment as a hate action and consensual love, or consensual sex, is too sharp of a draw. It seems to me that in a lot of what often passes as consensual sex are cultural elements that move quite a bit in the direction of what we describe as sexual harassment. And the anti-Alaska rules seem to recognize that in marital rape cases. And is that a bit of a problem in the analysis?
It's a bit of a problem only insofar I do recognize that some things that pass as consensual sexual relationships aren't really so consensual. I don't, by banning or wanting to ban sexual harassment, suggest that all consensual sex should also be banned. Obviously, I don't go that way. Although there are people that do take the position not that it should be banned, but that in fact consensual sexual relationships have the same coercive value. To be honest, I sort of ignore that in my where you draw the line between consensual activity and harassment is a difficult issue, and people would draw it at different places. I guess my point is there is a place at which we should draw it based on your understanding of the conduct, and I guess I draw it in a very different place than some people would draw it. But basically, I sort of hope people won't ask that question when I give this talk because it's a very difficult issue. All right. Thank you very much.